We're here tonight to talk about what we do and the legal topics you're interested in. We are Chicago lawyers. Alisa, tell me about your residential practice and the experience you have with evictions.
Hi, Dana. I work with a lot of landlords in the Chicago area, and I help them get rid of problem tenants and kind of regain their property and get control over situations that have gotten out of control.
How long does it take if someone needs to get rid of a tenant and wants them evicted?
It depends on the circumstances, and it can take anywhere from 6 weeks to 6 to 9 months, depending on the tenant. It oftentimes is a unique process, which is case-by-case dependent. Really relying on the tenant, and if they hire an attorney, if they file a claim against the building or against the landlord and claim a problem that's going on with their residency, it can exacerbate the case and really make it go on a very long time.
Is there an advantage, do you think, to taking a case on representing yourself when you're the tenant?
Representing yourself as a tenant, I think, can be a very simplified process because you just go to court and you explain to the judge and to the other attorney what your situation is. If it's a matter of the tenant not paying rent and there's a job loss or an illness, because those aren't really good defenses under the law, you can simply, as a tenant, explain yourself. However, if there's an extenuating circumstance...
You're going to explain yourself and you're going to lose, right?
Well, you're going to lose whether you have an attorney or not if your facts are such that you don't have a defense. So getting representation if you're a tenant is a matter of your ability to represent yourself and state what your position is. I think when in doubt, it's best to get legal advice. But to the degree that that is often difficult or it's not affordable or people have a preconceived notion about those costs, they can at a minimum get a consultation with an attorney, and that's usually free or very low cost.
So let's say it does take 6 months to get someone out of your building. You're not getting rent during that time. I mean, is there any kind of remedy for the landlord?
Absolutely. There's a process called obtaining use and occupancy, and so what the lawyer or the tenant or the landlord would do would be to ask the court for use and occupancy payments during the pendency of the case. So there's a very simple process, and unless there's an issue or question that changes the value of the apartment during the proceeding, like there's a claim by the tenant that there's damage or an infestation of pests, that would raise a question with the parties of what's going on with the value and maybe why it should be lower. Otherwise, it's very simple, and all the landlord or their counsel has to do is ask.
And who makes the payments?
The tenant. The tenant has to make the payment during the pendency of the case.
Wow.
Are the rules
Absolutely.
different between the counties, or?
No, because Illinois law under the Forcible Entry and Detainer Act controls all residential evictions. While there might be local ordinances like there are in the city of Chicago, by and large, evictions go under state law.
I've heard that there are some extra protections for tenants in Chicago. Is that true?
That is true. Although I wouldn't describe it as extra protections, because if a landlord is following the letter and spirit of the law and keeping with the simple things that they have to do, it's very easy to avoid a situation where a landlord doesn't do what they're supposed to. But a corollary to that is if a landlord doesn't understand their obligations in leasing, then they can certainly be called to task for any mistakes that they make.
How long do you think your average forcible eviction case takes?
Probably 2 months, and the reason is between the time of filing a case and getting into court, it's usually a minimum of 2 weeks, and there's a little time built in there for the sheriff to serve the summons. And then almost automatically a case will have a couple of continuances. It's very standard, but those continuances are usually only a week, maybe 2, depending on scheduling. So if an order of possession is entered on what you might call a standard case, that if it's by agreement, oftentimes there'll be a 30 or 60-day agreement, kind of as a very common practice. If it's judicially ordered by the court, then it could be anywhere from 2 to 4 weeks.
So how much would a process like this cost?
Average cost for evictions, I've been in practice over 10 years, is about $1,500. But that isn't something I quote flat fee per se. I charge hourly, and some attorneys will obviously state that they have flat fees, but typically in the flat fee scheme, those only cover a certain number of appearances. So if a case went beyond that minimum, it would cost more than the flat fee. So in my practice, I just charge hourly, and that's, I would say, by and large, that's a very good average.
So it sounds like you can have an attorney charge you a flat rate and then have a hybrid agreement where they're going to be charging you if they do more work than what they thought your case is entailing, or it sounds like the attorney can be charging you a billable rate from the get-go.
Very much so. I think a lot of attorneys will charge on either a per appearance flat fee basis, or they will get a general retainer agreement with themselves and the client where they'll agree to represent them for the duration of the case, no matter how long it takes, or they will make alternative payment arrangements. So it really takes all kinds, because there are such a vast array of attorneys and law firms and pro se parties working in the courts in the eviction area. So there's probably is a number of different types of agreements.
Okay. Well, I have a question about your clients and when you represent them. Does the attorney-client relationship end at a certain point, or do you remain their attorney in an ongoing, in an ongoing manner, even though their eviction case is over?
I think that a lot of it depends on how the lawyer and client think of one another. I think from the lawyer's perspective, once a client, always a client, but that doesn't mean that there's a file open in the office. And I think similarly, once a client finds an attorney that they trust, it's very common for them to think of John Smith as, he's my lawyer, you know, I can call him for anything. So I think to a certain degree, the attorney-client relationship stays, because the lawyer has an obligation to keep the client's secrets, which I think goes on.
Well, it's interesting you raised that that way, because in my practice, it's primarily transactional. In probate work or in estate planning, the client comes in and you have a consultation and you discuss the steps that we need to take, but really they're hiring me to do a job that has a definite beginning and a clear end. When someone comes in to make their estate plan, they're telling me which documents they want prepared, they're telling me how they want their estate distributed. I make drafts, they approve them, we meet and sign, and I ultimately deliver these documents to the client and advise them at that time. But the question is whether that attorney-client relationship between myself and the client passes that time, and I would say that it doesn't.
I think it depends on how you think of it, because if the relationship ends and you put the file away in the cabinet, in theory it isn't going to be raised again, and thus you won't think of that client or have any reason to talk about that client unless and until they call you or have some future contact.
So what if something went wrong? I mean, wouldn't they pick up the phone, and wouldn't you be the first person that they're going to ask questions?
Yeah, and I expect that they would probably call me back, especially if they had a question several years or sometime later, maybe something happened in their lives that warrants a change to their estate plan. But I still think that our relationship as a current client with an attorney has ceased to exist after I deliver their documents. And I do send them a letter indicating that that engagement has ended, but they're always welcome to call me back. And then I would say, if they do contact me again, that our relationship has been reinstated. Because the truth is that several years can go by, they can contact other attorneys, they can proceed with their estates in other ways, in other states, in other communities. So to have this open-ended attorney-client relationship out of my office, I think is too unpredictable. And so it's clearer if you just recognize that the attorney-client relationship ended at the time that the transaction was completed.
But if they pick up the phone and call you, doesn't the attorney-client relationship begin at that first phone call, regardless of whether they've signed a retainer agreement or not?
Well, I think it's important to clarify that, especially when you're talking to an attorney and you're asking them to do some work, then it's clear. If you're just asking them for some information or a direction, then there might not be that relationship established. And so communication is key.
I think that could also go into your retainer agreement. Different lawyers have different ways of communicating what is the scope of the relationship and what are the rules within it. So that would be a good thing to think about for any lawyer and any client, is to have a clear idea about what is going on and when that relationship ends, so that there are clear expectations
Right.
from the get-go.
And Ish, do you find that a lot of your clients call you back after a divorce?
They do, and a lot of them aren't too pleased with the outcome, which, makes me think, are there winners and losers at the end of a divorce? Because when we think of litigation, when we think of trial, we think of establishing your case and really advocating on behalf of your client so that they get their desired outcome. But I don't know if that's really possible in a divorce. It seems like there's a lot of things to feel really upset about because it is such an emotional process.
How do you deal with the client's expectation as the cases go on?
Well, I try to get the client to set small goals for themselves. Everyone's going to have different priorities. And I try to be really honest. Very rarely will you have somebody who, quote unquote, wins across the board. But if you set really small goals, you kind of manage those expectations so that they understand that not everything's going to go their way. But if there's one or two things that are really important to them, then we try to help negotiate that. Divorce is really about settlement. It's about negotiation. And it's about really trying to figure out whether or not two people are going to be able to move forward with their lives when the whole case is over.
Well, maybe the act of moving forward is the win, and that's an important message to send to the client.
That's a really good way of looking at it.
As soon as you've gotten out of that valley, the sun will shine again.
I like that.
Good point.
Thanks.
What do you think about after the Justice Department report today? What's next for Ferguson?
I think everybody in Ferguson needs to be fired, and the governor and the mayor, at a minimum, really need to get in there and clean house and get some strong leadership.
Wow, that is a strong opinion. What do you think?
I mean, I'd be scared to live there. I'll be honest with you. I mean, if you're walking down the street, it just feels very unpredictable. If you don't have a really strict rule of law that you can really depend on, if you don't believe that law enforcement is necessarily on your side, they could be or they could not be. I think it leaves the citizens feeling quite vulnerable.
I think you're right. And at the end of the day, if anybody living in a municipality like that lacks trust in law enforcement, then a lack of trust is going to equate to a lack of respect. And once respect is gone in any kind of relationship, it's going to easily be fueled and create a large fire. And Ferguson, and I think surrounding St. Louis counties, really have a lot of work to do in the coming weeks to find some peace. But I think the citizenry have a responsibility to take a step back as well. And this isn't just the government against us, and we're the victims and everyone else is the bad guy. I think that people that are looting and having a lot of negative commentary are really
Have a really good reason to do so?
Absolutely, but at the end of the day, if we all have to take responsibility, and if anybody's committing a crime or doing something improper, then they have to deal with that, and they have to just really look at what's going on. And if everybody sweeps in front of their own door, then I think it leaves room,
I think part of the problem is it doesn't seem like everyone's held accountable for doing things that aren't proper under the law.
You're absolutely right, and I think that's where the housekeeping comes in, because if you're having government officials and agencies that have a biased and unfair way of looking at things, then you're not going to get proper administration, and that's got to come from the top down.
Do you feel like in Ferguson everyone has to take sides?
Who do you have the biggest problem with?
I think after the Justice Department report, most certainly the government. Absolutely, because that is a systematic annihilation of due process and equal protection under the law. And police officers take tests on the law as much as lawyers do. And at the end of the day, if you have this much abuse against this number of people, and even these messages that are coming out that were intended to be private, they show a clear pattern of abuse. So I think it's all come out, and it's great that the Justice Department did the investigation.
I have a problem with polarization. I feel like people feel very strongly, very passionate about their position without taking into account the other side. And there are always two sides to every situation.
Yeah, that's a good point.
It's not just us against the police, and it's not that all police are great or all police are bad. I think we
Right.
need to understand that there's a little bit more gray in the world, and people need to be okay with having nuances in such a large conflict that's really taking over our whole nation.
But that, I think, brings up the point is that if we're going to talk about the nuances, people like Darren Wilson need to be tried in a court of law where those nuances and facts come to light. And if you have a lot of officers dealing with issues of deadly force, maybe not specific to Ferguson, maybe not only do we have to examine why deadly force is necessary to subdue somebody who's unarmed, and why we're not shooting in kneecaps rather than shooting to kill, it begs the question of why we're talking about the police and these tactics without examining the training methods and bringing the people to task that are making these decisions. An unarmed person is not a threat to body and life in the way that I think the police have lately been claiming.
Well, what about fear? I mean, maybe if fear is such a driving factor, you're in no position to say that.
I think that a person wearing body armor who's trained to deal with the general public and who's trained specifically to deal with people that can be insightful ought to know better. And if you lack the capacity to make that kind of decision, then perhaps you shouldn't be a police officer. So if Darren Wilson or somebody like him lack the ability to deal with an unarmed teenager, then I have to wonder why he's a police officer, and I have to think that the bar should be raised. Everybody's good at a job.
So at what point should someone contact you?
I think whenever they have a question that they can't answer themselves or they feel that they're getting conflicting information. Since I do trial work and business litigation in addition to real estate matters, I think it could come up really anytime during different types of matters, but I think whenever the client has concern or there's a service of some papers in a case, any formal legal document that gives a deadline, is, I would say, most definitely call an attorney right away. All too often, I will get a call of a court date the next day, and I think people need to realize that a lot of clients will require an attorney to schedule things in advance, and calendars fill up very quickly. So I think the earlier the better.
And I would actually say, before you think you need one, because everyone is always calling us too late. And usually by that time, certain things have happened that are really difficult to undo. So I always advise people, if you think you're going through a difficult situation, especially in a bad marriage or if you're contemplating divorce, most divorce attorneys, I think I can say this, most of them offer free consultations. A few will make you pay, but if it's free, pick up the phone, get educated, learn a few things about what you need to be prepared for before you get served with those papers, and you're going to be much better off.
I would agree. I charge $100 for a consultation, and that's really kind of a way for me to feel out a client if they're prepared to bear the freight of a case, and I can get all of the necessary information and see where they are. But it's most consultations are going to be free or reasonably low cost, and it's important to get that information, and I think also to shop attorneys and figure out what's the best relationship, because if you don't have a good relationship between the lawyer and the client, regardless of whether the case has merit, I think that's going to be very difficult sailing.
Yeah, and you said it best when you said some things can happen that cannot be undone, because in my practice areas, you're dealing a lot with end-of-life situations. In the field of elder law, in the field of probate, you are talking about what has been done during life. What did the person intend to do? Was that done properly, validly? And so a lot of people come to find out that something was done improperly or invalidly, and now it's too late. So,
well, let me ask you this. When it comes to probate, doesn't the matter start at death? Is there anything that needs to or should happen before your loved one passes?
well, the flip side of probate is really estate planning, and that is if you want something to pass to your beneficiaries in a certain way or certain percentages, you want to consult an attorney to make sure that your estate is going to pass that way.
You know, I kind of wonder, do you think that's more of a cultural thing, that in some neighborhoods and in some groups of people, we just don't plan ahead like that?
I think it's very common because we don't want to talk about as people what's the negative, and we tend to think that this won't happen to me or my loved one, so I can always put that off. But I think what a lot of people, especially with estate planning or even with disputes, they don't realize that just getting a consultation or just getting a preliminary idea about what the project or case would entail is not only going to relieve the stress of hiring the attorney over the long term, they'll get more information about the costs and the process. And so it's so informative for the client to just meet with somebody for an hour. They don't have to go through it, but at least if they know and have the information, then they're better able to make a decision and find an attorney that can work with them. So I recommend getting a consultation. An hour of your time and a little bit of money may very well work to your favor in bringing a comfort level with your situation that you didn't have before.
Consultations do vary though, because it is common to have paid consultations in my practice area. It's uncommon to have an unpaid consultation.
Don't you find that's partly because they run pretty long and they're pretty substantial?
They do run pretty long. You cannot get past a consultation in less than an hour, but I have had them run up to 3 hours before because of the amount of information that you have to go through for this kind of matter. And really, our consultations in estate planning and probate and disabled adult guardianship cases, you're gathering so much information and you're at that time processing it, and you are talking to your clients or your prospective clients about what needs to be done,
Right.
what their parameters are. You are giving advice in that consultation that they are absolutely should be, heeding. So it is typical to have paid consultations for our practice areas, but it's interesting that other practice areas,
It's pretty unusual for us.
the consultation is unpaid or even possibly
I
a
charge
hybrid.
I charge for all of them because my time has value, and where I'm talking to a client and advising them or figuring out whether or not the representation can materialize, I'm not working on other cases that have an hourly fee. And so as a result, it's a money loss to market myself to a client that's sitting in front of me. If they want an opinion on whether their case has merit, they need to be able to bear the freight and have an ownership. And I find that clients that are willing to pay a nominal fee for time have a lot better participation and voice in their case, and that translate over the whole relationship.
Great. Well, it
positively.
has been a great conversation. Thank you so much for joining us. We hope that you enjoyed this show. And if you have any questions or comments, please call the show and give them to us. See you next time. Good night.
Good evening, and thanks for joining us. We're here to talk about the law and to entertain your questions and what we can do to make law more accessible. We are Chicago Lawyers. So I'm interested to talk to you, Ish, about your practice in family law and how people come to hire you.
Well, one of the big topics in family law has to do with what we call maintenance. It used to be called alimony, but the
Okay.
law has sort of changed the terminology, and it seems to be a huge concern to parties that are divorcing. And if you're familiar with the concept, the idea is, should spouses have to support each other once they are divorced?
Is that dependent on whether one or both spouses is working?
there are a lot of factors that the court takes into consideration. So first, the analysis is going to be, does the judge think that maintenance is appropriate in this case? And in some cases, it's not. And so there's going to be a whole test that the parties go through, and the judge is going to do an in-depth analysis. And then once the judge decides that it is applicable in your matter, then Illinois has just adopted a new maintenance law that applies a particular formula. It's very mathematical, and I'm a little freaked out by that. I mean, does anyone else here think that math is a little inappropriate when you're dealing with relationships?
I certainly think it's inappropriate when you're dealing with the law, but just the same, I guess it's necessary in some cases.
Is there a threshold you have to get over in order to even qualify for maintenance?
Not really. I mean, to be honest, as soon as you're married, the law looks at it as there has been a commitment, almost like a financial arrangement between two people. And when we dissolve that arrangement, they think that maybe there should be funds that still transfer between the parties to maintain the standard of life that they're used to. And I'm just not sure that's appropriate anymore. I mean, it is 2015.
What about if somebody doesn't want to work? Does the law impose an obligation to make somebody go out and get a job or a career, or do something to better their lives if they hadn't done that during the marriage?
Right. So that's probably when the judge would rule to have some type of a temporary maintenance in place. They actually may encourage you to rehabilitate yourself and to take college classes or go for some kind of job training. So sometimes there's a term placed on it where, you know, maybe for 3 to 4 years, your ex-spouse will support you, and then after that you're on your own.
So you mean a judge could actually say you have to get it together in formal terms, and you have to grow up and get a career?
Oh, absolutely. And I think what bothers me about maintenance so much is that I think as a society we think of ourselves as pretty independent. I mean, do you think it's appropriate that it exists at all?
I guess it's necessary, and it's going to be case-by-case basis. I mean, if someone's not capable of supporting themselves and has been used to what their spouse has been providing for them, as a society, we have an obligation to look out for those that are less fortunate. And so.
Well, I mean, you say that, but that's almost humorous because there's the recent case where a billionaire got divorced and his ex-wife rejected her maintenance award, which was in the amount of $1 billion. She thought she deserved more.
I guess she would have to establish what it is that was regular in her day-to-day life that justified a
Do you
billion
know how long they were
dollars.
married?
It was in excess of 20 years, but really, does that even matter?
And the billion she wanted was for the year?
Well, no, it would have been a lump sum award, which is possible under certain circumstances.
Oh, so it's not in payments. So
It could be.
You have an option of getting it in one lump sum and you're done, or you can get a monthly payment for a period of time.
That's correct. A lot of it depends on what the parties agree to. And as long as it's not unconscionable, a judge will honor an agreement between two parties.
Does it matter if the agreement's made after the marriage, or could that be an agreement that was made before the marriage, like in a prenup?
That's a really good point. And I think that's why a lot of younger people are really driven to do prenups these days, because they sort of see that a lot of the conflict and stress caused by divorce could have all been prevented with a little bit of planning.
Yeah, I have had people ask me about prenups more commonly in recent times than in the past. I think it's more common
Is there a
now.
little bit of overlap, do you think, between your area of practice and mine?
Well, I do think estate planning and ultimately probate administration starts with your family, and so all of these issues within family law transfer over at the time that you're doing your estate plan, and then if you need to go through a probate administration, you're certainly going to have similar issues. One of the issues that has come up in recent times is called equitable adoption. Have you heard of that?
Never heard of it.
Equitable adoption is a term that's been coined, and it is now legal in Illinois to have a informal adoption of a person by holding that person out as your child.
Really?
So this is not
Like what Whitney Houston did with Nick Gordon?
Oh.
Who's Nick Gordon?
Nick Gordon is a young man that Whitney Houston took into her home for many, many years, and she raised him side by side with her biological daughter,
Good point.
Bobby Christina.
Exactly.
And she held him out to the world as her son, yet because the two siblings, or the two young children, knew that they were not blood related, they didn't necessarily see themselves as brother and sister. And now, due to her injuries and the things that happened prior to her entering the hospital in Atlanta, there were questions about whether or not they were boyfriend and girlfriend or married and had a romantic relationship as the result of having been raised together.
Okay,
So
well,
Whitney Houston did
let's
hold
take-
that
let's
young man
take-
out as her son.
Well, let's take Whitney Houston's case, and I'm not sure what her estate plan consisted of, but let's say she didn't have one. And so now her estate has to go through a probate administration because she meets all that criteria. You can have someone come in, Nick Gordon likely, and say, this person held me out to be her son. I have a right to inherit against her estate as an heir. Well, your immediate thought would be, if you were arguing against Nick Gordon, you would be saying, you're not her child, there's no formal adoption, there's no legal basis for this.
So I'd say you'd
And-
lack standing.
Right, and your case is dismissed. But in Illinois, we have had a case that went up before the court, and it was determined that someone could be. It could be the case
Wow,
that
how
you
did
are
they determine
equitably
that?
adopted.
Wow.
So there must have been very fact-driven that there was a long-standing history of the
Absolutely.
relationship between the parties, and they had. There
Absolutely.
must be a holding out of parent and child to some degree that is both formal and informal to probably cross that threshold, because just having a younger person and an older person carry on it doesn't necessarily cross the line of becoming
Right,
family.
but it might not be a young child. I mean, if you're someone who is raising kids and you've got a kid down the street who is over at your house eating spaghetti, 3 or 4 nights a week because their parents work late, and you take him to and from extracurricular, so this becomes a family friend over a period of years. But let's say 10 or 15 years later, these kids are now adults, and you may have a friendship with the now adult child, and then your life ends, and this child makes a claim against your estate as an equitably adopted individual. It could become very complicated.
Well, that sounds like you're just opening a whole can of worms. I mean, do we really want the kid down the street to feel like they have a claim to our inheritance?
So good
Yeah,
job,
and-
state of Illinois. That sounds like a winner to me.
Well, I mean, I don't mean to make it sound like it's very easy to accomplish this, and certainly this is relatively new and there is a lot of case law to be developed, but it has been on the minds of many estate planners. The judiciary has talked about it. We have had commentary about what sorts of complications can arise as a result, and time will tell to see how this plays out.
I think that's a real switch for us in Illinois because, as you know, common law marriage doesn't exist here. So it's funny that I can live with a man, we can share everything, we can share property, we can even share children, and yet Illinois will not consider us legally married.
I think that's going to be an interesting point to be made in various appeals cases where that argument is made. That because there is no common law marriage in Illinois, that should militate against finding of an equitable adoption. So I think a lot of appeals lawyers are really going to jump on that and find that is one way to look at it. And then as other states, their law develops, I think that'll be a very common theme.
Well, it sounds like really a public policy issue. I mean, what do we want to promote? Do we want to promote sort of loosey-goosey relationships where you don't need a piece of paper to prove anything and you're just going to have a lot of testimony about spaghetti dinners over at your house? Or do we really want to make things formal so that everyone understands? I mean, isn't that what the law is all about?
I would think so, and if anybody can claim heirship when somebody dies, I think it's going to really blow up the courts and the probate administration and family litigation and even business litigation, because heirship and is going to really cross the line with kinship and friendship, and it's going to become very blurry. So I
Well, the
think
law was developed as a result of trying to make this an equitable available response to a problem that was not resolvable otherwise. Because we had in this case a situation where the decedent had intended to adopt this child, but never formally went through the process. And so there was enough evidence to convince that the adoption process formally would have taken place, but for extenuating circumstances. And so there was a reach in order to make this happen.
I think that could even translate over into current issues with immigration, though. I mean, I think you have a lot of cases in the media and in immigration kind of forums where, you know, someone could say, well, my parents meant to get me citizenship, but it never happened, and so I should be granted citizenship, or I should be granted certain privileges that come along with X or Y because that was what we thought. And,
Right,
and I
the
think
intent.
that's the problem, is it's going to open up this Pandora's box of, well, this is what we meant to do versus this is what we did, and I think it's going to eviscerate the rule of law that comes by way of a contract.
Don't you guys remember that in law school, the difference between having an intent and actually carrying out an action? I mean, are we going to start giving people powers and rights because of their thoughts if they never act on them?
Law school.
Don't take us back. Well, it brings me to the point of dealing with an appeal and dealing with intent and how you come up with a case and how in the trial court the case goes along and you deal with everything that happened, and you have to inherit that set of facts in an appellate situation and apply to that higher court to get the relief that your client is seeking. And
Well, let's say you wanted to appeal a case. Is that like a whole new engagement agreement? Do you have to put down a whole new set of funds to make it happen?
I think in certain cases it will come up enough in advance in the initial kind of engagement that the client and attorney will talk about that. I know that in my practice, my retainer agreement, being that it's hourly and the client pays by the month, that if the case goes to an appeal, because they've directed me to do so, then I just continue to work with them as I had through that process. I think, as Dana was mentioning, if the retainer agreement, you know, delineates a certain starting point and a stopping point, that may come up. I know plenty of attorneys that only take cases to trial, and they don't necessarily create any expectation in the client that they would take the case. But I think the problem is that the attorney who handles the case from the beginning is absolutely the best lawyer to do the appeal. If you give someone else a stack of your boxes and you tell them to learn this in a 35 or 90-day period of time, they're never going to have enough information from having lived the case as the initial trial lawyer. So it's really important in an appeal situation that you really take into consideration, as both the lawyer and the client, of the relationship as a whole and how the information and the case was preserved to protect it for an appeal. Things like hiring a court reporter. I know that many clients don't know that even when they send their attorney to court, that there isn't a court reporter necessarily included in that, and that may be an extra cost. So
Yeah, we have that in divorce too.
it comes down to communication, and the lawyer's job is to guide them through that process.
And so is there evidence which is excluded at appeal that was included at the trial level?
There is nothing at an appellate level that's excluded. The entire record of everything that was admitted in the trial court and all of the things that are filed by the parties becomes part of the record, and it gets bound like in a notebook form, and then that becomes the record, and each page is stamped so that it gets a special number. So when the record itself is compiled, that's all of the documents that were filed. So if there was something excluded at trial, and it didn't make its way as an admission or an admitted exhibit, then the only way it would become part of the record is if there was an exchange with the parties in the court over it, or a motion that went to that.
And when you're going through an appeal, you're not going to go through all of the testimony again. You're not going to go through new evidence. You're basically limiting yourself to this notebook-bound information, right? And you're going to then argue those points again to a new set of judges.
Well, I'll start from the last point first. There's definitely a new set of judges, but you do, if their testimony is included within the record, meaning that the testimony was transcribed by the court reporter and put into a paper format, most trial attorneys will have that actually admitted as part of the trial court record, so that the appellate court or the Supreme Court would be able to have the benefit of what was said on the record. So that becomes part of the case. Whether or not a fact or an exhibit or a problem is revisited depends on the appeal. So to the degree that some appeals might make an argument that this exhibit was improperly admitted or denied, I think that was an error on the part of the judge. Let's review that. Other times, the argument can go to whether just it's a point of law that the judge implied incorrectly. So there are cases and appeals I've personally handled where we are visiting such narrow things as testimony and what the testimony proved. So I think it's case by case and definitely practice area by practice area. But I think the overarching idea is that not only are they very detailed and involved processes that in many ways reopen the entire case, the appellate lawyer has to themselves absorb the entire case to be able to teach the court what happened, what should be happening in the future, and to guide them through that record so that they can make a decision in regards to
And the
the case.
decision is you lose, right? I mean, no one wins an appeal ever, do they?
I've never lost an appeal, so I can say that to the degree that if you can articulate clearly to an appellate court of what should happen, the law will be on your side or it won't, but I think a lot of it just goes to clear communication.
Isn't it true, though, that even if the judge agrees with your point and you've been very clear in laying it all out and you say exactly what you want, isn't it true that the appellate court doesn't decide anything for you? All they do is kick it back to the trial court?
I think it depends on the case. If the appellate court affirms a lower court decision, the appellate court is saying, yes, trial court, you were correct in what it is that you did. If the opponent does not then desire to take that case back into court and deal with that, then the victory in the appellate court could conclude the case. If the opponent decides that the appellate court made still a wrong decision, then they have the option of asking the Supreme Court to review that. So generally speaking, there is a process in the appellate arena that gives people choice into how they wish to proceed. And I think, again, if you're talking about communication with an attorney, the attorney should be going over all of those options and avenues and playing devil's advocate so they can guide client expectations.
What if you find out new information after or during your appeal, after the original trial at the trial court level, and now you're in an appeal and you find out additional information for your case?
Do you mean additional facts or
Yeah.
additional law?
Additional facts to the case.
They would probably not have an appropriate kind of entry point into the case because a final order from a court of law disposes of the case as it was at that point. But to the degree that you could always ask an appellate court to deal with that, certainly the one thing about the law that I think is common of all practice areas is that it never hurts to ask. And the worst thing that can ever happen in a court of law is the judge will tell you no.
And
So-
it could be a very expensive no if you think about it.
Most certainly, but just filing a motion based upon a new fact in either of the courts would probably not be cost prohibitive.
Dana, I had a question for you. Is there any such thing as an appeal when it comes to estate planning and probate?
No?
What about like if someone
Just
wanted to contest a will? I mean,
No.
Dad cut me out of the will and I have a problem with that. What do I do?
No, I was trying to be funny. I mean, certainly, will contests and probate litigation is a matter of course because sometimes you do have different perspectives on what happened. And so it's a natural area of law to have questions about what happened in the past because your main kind of star witness is not around anymore to validate everything. And so that's why it becomes very important to, document and properly exercise, the execution and that sort of thing. But to answer your question more broadly, if someone feels there is something wrong with the administration of a probate, or if someone has questions about what should they do at this point, they can contact an attorney to get involved in an existing probate estate, or they would contact the attorney who is representing the administrator, because possibly that attorney and the administrator did not have the contact information for the person who is initiating the contact. You know, it happens that there are unknown heirs. Sometimes people cannot find these people who are necessary interested parties.
That's very informative. I'd like to ask a quick kind of question, segueing into something that's come up recently. What do the two of you think about the Innocence Project and this pro bono kind of not-for-profit organization that is helping people undo unfair convictions in the criminal area? Have you heard anything about recent cases?
Well, one thing that comes to mind is, what does justice really mean? I mean, when you think of wrongful convictions, one might look at it as, oh, they were exonerated, right? They get to walk free, you know, go live a happy life. But really, I mean, you've lost decades that the law and our system can't really repay. So what is justice?
Well, I mean, either way you look at it, it's not a perfect system. I think we are doing the best that we can. We have to balance the interests in trying to criminalize those who deserve and committed offenses. And we work on the best evidence we have, and that's why we have this system where we go through trials and we have the ability to raise it to the appellate court, and I think the entry of DNA evidence in order to exonerate these people has been, a wonderful growth in our legal system, because even though they've lost decades, we can only do the best that we can. And at this point, we can give them the rest of their lives. Until we get a better system, that is what we have.
Well, I have to respectfully disagree. I don't think we're doing the best that we can if we're locking innocent people up after trial, after evidence. If you think of the burden of proof, beyond a reasonable doubt, how do we mess that up? And this isn't just happening once or twice. I mean, this seems really systemic, and I don't think that guilty until proven innocent should really be the way to go.
I think part of it involves, though, the competence of defense counsel. And if you have a capital case or something that can really lead to long-term incarceration, and you're dealing with people that got public defenders, when you examine public defenders' caseloads and the amount of work that often might go into the case, as opposed to the amount of work that goes into a paid retainer agreement, just the Jodi Arias case, those defense attorneys got from the state over $3 million. And that obviously isn't necessarily a reflection of worth, but to the degree that they do a lot more when they're getting paid. And when you have pro bono attorneys or low-cost attorneys that are overworked and not able to bear the freight of their workload, it's going to translate into poor defense. And I think that can be in the criminal or civil realm, but I think that part of the overhaul of the system is really applying some of the issues on more than one level.
And I think that's a valid point. But in their defense, these pro bono attorneys and these public defenders really often practice from the heart. I mean, they are there to help these suspects defend themselves because they believe in the right to get a bite from the apple, to have their say in court. And the ones that I know are really not there, building their wealth on the side. They're there for the reason that they want to help these people.
I mean, that may be true, but if you have people who want to practice from their heart on the one side, and on the other side you have a prosecutor who's trying to get reelected next year, I mean, think about who's going to win.
Well, I think that's the issue, is that we have to really examine more closely who our attorneys are and who our government officials are, and really dig a little bit deeper in what we know about the system and how we can make it better. I'd like to thank you all for watching, and please call the show if you have any questions so that we can continue to inform you in Chicago area about what lawyers do best. Good night.
Thanks for joining us tonight for our roundtable talk. We're going to have some conversations that hopefully interest you and make you ask some questions and entertain you. So, what's going on?
Not much. What's going on with you two?
Not much. I'm glad to see you. We're going to be talking about conflicts of interest. I want to know what you guys think about your practices, and if you have any questions when you have people coming in and hiring you. Does it come across your mind, is this a conflict of interest for me? Can I take this case?
I have such a small practice that I run as a solo attorney, so my conflicts checker is in my head. And unlike the large law firms that have entire departments of lawyers that deal with conflicts, if I've met you before, then I will know your case if you've hired me. And as a result, my conflicts process is kind of internal. But I think it comes up, and I ask those questions of myself if I find that the party, sitting across from me in the client chair brings up somebody that I know or somebody that I've represented. So it comes up more organically, and I don't undertake to ask a lot of questions to them to figure out the connection. I'm not looking for a conflict. It's just that if it comes up, I have to deal with it.
I bring it up because in my practice, I have a lot of people involved in any one matter. The client is typically the elderly person, and oftentimes they rely on their kid or sometimes a younger family member to bring them in, and the person who is accompanying them to make them feel more relaxed and is primarily talking to me and giving me the information. So the prospective client or the client that's sitting there, that's the person that I have the relationship with.
Right.
But the person that I'm doing the most communication with is the child or another relative or someone not the client.
That happens for me from time to time. I just did a grouping of wills for a Filipino couple, and the children did the translation.
Oh,
Well,
yeah.
that's really interesting when that happens in court, because we'll have translators, and we actually swear the translators in divorce so that we know that they're going to translate and be accurate and know that they're only there to represent exactly what's going on. And we really have to distinguish between who is our client and who is not.
I find that it's interesting in eviction cases that I have the translator is not sworn in.
Oh, really?
Yeah, I've rarely seen it.
Well, sometimes the person that I'm talking to is thinking that I have a duty to them. So I always have to remind everyone that's at the table or in the room who is the client and who these duties are.
Well, how do you do that? I mean, do you just say, "I'm not your lawyer"?
Well, no, I always inform about the process. So I'm sure you guys do the same thing.
Right.
But I always make it clear in writing that when we are establishing this relationship, this is the client. I take direction from this person, regardless of who is talking to me or regardless of who is paying the bill. That's another one. Do
Right.
you ever have that? They pay the bill, so
Yes.
now they think they have some say in what goes on,
Yes.
and that's not actually the
Well,
case.
I mean, it does make sense though, right? That's how we operate, is the people with money are the people with power. So if the people are hiring you, they probably think that they should have some say. Otherwise, their loved one would not even be in your office to begin with.
But there could be a conflict of interest. I mean, your duty runs to your client, and you need to zealously represent them in their best interest, and there may be adversity in the future. So,
But maybe you just have to advise the person to whom you're talking that maybe they need a separate attorney. And that can be a difficult conversation, but if you bring up the fact, Mom and Dad are my clients, and the two twin daughters, Sally and Jenny, I'm talking to you, but you're not my client, and you may need a separate lawyer. I mean, that can open up another conversation, but it's maybe a good way to help drive home that point that having a separate attorney means you have separate needs.
I think a lot of people don't understand that about divorce law as well, is that we can only represent one party. And sometimes I get a husband and wife team that walk in and they say, we want to hire you, we agree with everything. It's what we call an uncontested divorce, and it's pretty straightforward. But I always have to say, I can only represent one of you. There's only one client, there's only one attorney-client relationship here. And so I always make it really clear to the other party, they're free to go and seek counsel if they want to, and that's their choice.
I was approached by a grouping of friends, a couple that I know, and they got an uncontested divorce, and they both approached me to handle that. But ultimately, I didn't end up serving as anything other than a sounding board for them handling it themselves, because
So wait
it
a
was
minute.
very simple.
I thought I have heard of cases where a husband and wife hire one attorney, he drafts all the paperwork, they sign off, and life goes on. Is that
That's
really not the
legal.
case?
That is not the case, and anyone who tells you that that's possible is probably not practicing the kind of law that is going to get them very far.
But isn't there a situation where if one client consents to the dual representation in law, that it's appropriate?
I would say that dual representation has been done, and it's never advisable. I'm not entirely sure that it falls under our ethical guidelines as attorneys, because how can you really serve two masters? You've heard of that, right?
Sure.
What if one party wants one thing and the other wants something else? I mean, whose side are you on? Divorce is complicated enough. We don't really need fighting going on in my office.
You know, I always
I
think
agree.
about that with the realtors.
Yes.
The realtor wants to sell your house, and he wants to be the buyer's realtor too. He wants to.
I'm actually working on some legislation to try to abolish that, because in the realty context, you can never have two masters. But I think in an uncontested divorce, you could, if the matters was truly uncontested. And that's the problem, is it's so individual, and what's going on with each client file is going to be different case to case. And even when they're fighting over the pets and all of the property, it really goes to, what happens and how do you deal with that.
Pets have become such
Oh
a big.
my goodness, don't get me started. They're not people. Can we all get that straight?
No,
My
wait,
cat's a
whoa,
person.
whoa, hold on.
My cat's a person.
Hold on. I think you've got some
Well,
controversy
think
here.
about it. I mean, the law is very clear. There's property division and divorce, and then there's custody matters with regards to children. We're talking human beings. Pets are not people. And I understand that people develop very close relationships with them, and they buy them all these designer clothes and, take them for walks in the park.
I know.
But they
They're
have to be
dressing better.
nurtured just like a child. If you left your animal out in the cold, you would be cited by the authorities for abuse. So
I just got to say, those sweaters,
How about the strollers?
they are
Have
ranking.
you seen the doggy strollers?
The sweaters are knocking my sweaters out.
I have a cat that wears sequins, so I'm just saying.
Well, but I mean, we can laugh about it, and some of it is quite humorous, but I think people are really struggling with the emotional attachment they feel to pets that the law doesn't recognize. So what's out of sync here? Does the law need to just, get up with the times, or?
It's an interesting question, because a lot of our law develops as society changes, and I think it's definitely changing.
Well, the pets are $1 billion industry, and since Rome wasn't built in a day, I think there is going to be an evolution of changing attitude toward protection of animals. I mean, when you have a will, if there's a provision for a pet, that's absolutely honored and respected in most jurisdictions. So I think you have pet insurance. I think then and that can go to a lot of issues. So I
Yeah.
think it really is an open topic that probably is not anywhere in sight of closing anytime soon.
Yeah, I definitely see it more commonly in my estate planning practice area. People want to provide for their pets. A lot of times these pets outlive their owners. I've added it to my regular intake form to ask them all about their pets. And in fact, it started out with what kind of pets do you own and what are their names, and now it's become who's their doctor, do they have insurance.
I think we've taken things way too far. As far as the law is concerned, a pet is a lamp. It's like the piece of jewelry that you're fighting over.
I would put a pet in an eviction if I thought it was appropriate. And when I do an eviction case, I tell the sheriff if there are pets there.
You kick the dog out on the street.
Oh.
That is so cold.
But you're saying pets are like a lamp, so I can put a lamp on the street,
wait a
but not the
minute.
dog.
Well,
the
that's
dog will
true.
have to go. So
You have a
no,
point
I mean
there.
when there's an eviction, everybody has to go. So I think the sheriff would be empowered to take Fido.
Are there
out
more
and about.
dogs or cats in controversy with divorce?
It seems to be mostly about the dogs, and I'm not sure what that's about, but I think it has something to do with what people mostly fight over is custody and visitation, much like with children. So who gets to keep the pet? Are we allowed to move out of state with the pet? Can I get pet visitation so I still get to snuggle up with my little fur baby?
Do you draw up any of those agreements?
I have, and I've actually had a judge tell me that he's not willing to enforce it. And he pretty much did what you just did right now.
I would appeal that case. That would be fun. Pets are people.
Pets are people too. Have you ever had such litigation over a pet that people spend, you hear these cases, oh, it was over a tea set and it cost $20,000 and we could have bought it for $10 at, the store. Do you ever have any, or have you heard or have you experienced any crazy case about a pet whose visitation was in dispute?
Well, I'm not sure in terms of cost because a lot of attorneys don't share that information. But what I do know is that some divorce agreements have actually fallen apart because the parties cannot agree on a single provision with regards to what happens to the pets. And sometimes you have the similar thing as with sibling relationships where there might be 2 dogs and a cat. And do we really want to split them up because, they really need each other?
They do need
They're all
each
part
other.
of the same family.
So when your clients are talking to you about potentially hiring you for a divorce, are there certain things you're looking for in your relationship with them that you think would make a good union between you and the client?
I think the most important thing is you want people with realistic expectations. I know it's going to be trouble if they think they're going to win everything, they're going to get to keep all the property and all the pets, and they're going to get custody of the kids, and they're going to get maintenance and have everything in the world go their way. I run as fast as I possibly can from such a client because it's just not going to end well. That's not real life. But if I meet with someone and they understand that life is about compromise, that it's probably best for you to agree on more things than not with your spouse, then I think that there's some good work that we can do. And I'm more than happy to help them with that process.
What would you tell them? What would you tell them about yourself that they should consider when hiring you?
I think I tell them that I like to be painfully honest. I don't know if you've realized that or not.
Just a little bit.
What do you think? What would you think is important?
Well, I think, bringing an entire file and giving all the information. I have a lot of business clients in my litigation practice that don't give me everything that I need. And so oftentimes I'm chasing information, trying to figure out what it is that's important and the delivery of information from the client to me. And I like to tell clients, just give me everything and I'll decide what's important. And I think that translates to any kind of practice area, but I have a client that routinely filters the information and only gives me what he wants me to have. And there have been so many cases where that really works against them at the trial level. So I think just being honest with your attorney about, in a personal context or in a business context, if you deliver all of the information and let the lawyer make the decision, I think that ends up translating into a streamlined process for a lower fee.
Don't you think that sometimes it actually helps the client to be more open and honest? A lot of times people want to keep things to themselves. They think, oh, that's not important, or I'm embarrassed by that. But what I like to tell my clients is, look, if you're honest with me, we can develop a plan. We can frame this in such a way that it looks good and that, puts you in the best light possible, but I can't help you if you keep it to yourself.
Well, I think that's so true, and not only that, I think that's how all of us got such a bad reputation for skewing the truth, is that we were innocently trying to help our client's version of the story, and that backfired a time or two, and all of those bad apples have sort of poisoned the bucket. But I think that's exactly what the issue is if the client is making the decision about what's important, then the lawyer's job is much harder, and therefore much more expensive.
And Dana, don't you find that in estate planning, if people don't tell you everything, how are you going to know what kind of documents to draft? That could be really detrimental to a case, couldn't it?
That's impossible. I mean, you can't draft a comprehensive estate plan without having all of the information. That's critical, vital.
Well, how do you make sure you get that out of people? Because isn't it even hard sometimes to know what questions to ask?
Well, every 6 minutes I say, are you sure you're telling me everything?
Don't they have I think there's a checklist that's common in estate planning too, so you can just hand out the checklist.
And then I send out that letter. Just in case you miss something, call me back, and here's the summary of our conversation. And everything that I'm doing here is going to be based on the information you've provided to me. So for me, I have to remind people, I'm only able to do the best that I can for you based on what you tell me. And if you're withholding information, then you're only going to do it to yourself,
There was a case I heard about where this is a mother and father situation, and the father was accusing the mother of using drugs, and she denied it. And she was absolutely adamant that she had never smoked any marijuana ever. Well, the judge didn't quite believe her story, and he ordered a drug test, which, to everyone's surprise, came back positive. And when I tried to find out what it was that made Dad so certain that Mom had used drugs, she decided to say, well, the truth was, we used them together. Never thought that information was important. Funny how that goes, isn't it?
Definitely.
Was this a case you had?
Oh, I would never share that.
Ding dong.
Yeah, I mean, openness, honesty, those are kind of obvious requirements of a good relationship. But I think that even comes back to feeling a connectedness
Yeah.
with your lawyer. You know, you're not going to be open and
Are
honest
lawyers human too?
if you're if you're not feeling
are.
like you can relate. You know.
Well, and I think that comes across really in the first 5 minutes. I've had clients that have hugged me at the end of a consultation because, you know, I made them feel comfortable. And I think that's a lot of what it is hearing them and giving them a sounding board for whatever their questions are. And even if you don't end up helping them, you know, if you can make the process more simple. I think people don't call lawyers because they assume it's going to be too expensive and too formal. And if you can,
Well, you know, I have to
change
say, I
that.
take offense to that whole, it's too expensive. Have you ever heard anyone complaining about having to go to the doctor's office? I mean, doctors get paid.
They do, and I actually tell when people don't like the consultation fee. I use that analogy quite frequently to say that you have to pay to. I can't diagnose your problem like a physician would without meeting with you. And if you know, it's very common that people will give me that pushback. But as I've said before, if someone can't bear the freight of the consultation, then likely they can't pay the legal fees. So
No, when it comes-
it's an introductory kind of window into the mind of the client, and that's a good way to feel them out if you want to take on their case.
Yeah, and I think that you know it's generally common knowledge that you know advice from an attorney is going to be relatively expensive, but it's still a hard pill to swallow because you know it is in fact expensive, and I think what many people may not realize is that you know the cost that it takes to maintain your job as an attorney, and sometimes communicating that to people, I think we can, as a profession, do a better job of helping people understand why those costs are so high.
There was a Facebook posting recently on some blog that indicated why legal fees are so expensive, and it went directly to that point, and it basically was like, you don't understand how much time your lawyer puts into your case. You don't understand that they wake up in the night thinking about your case, or that when they're driving to work, they're thinking about something that pertains to one of their clients, and that we internalize
not
it.
even all the time outside of you know the office, but let's talk about operating costs that people aren't even privileged to. They don't understand necessarily that you're talking about malpractice insurance premiums, continuing legal education premiums,
Student loans.
So,
Well, wait a minute.
Speaking
When
of-
we're not thinking about our clients and doing all that busy work, what do you guys do for fun? I mean, do we have fun?
do you
We
blog?
do. I blog, but I consider
You
that
just
more
mentioned
professional.
that you read a blog, so that's what
I
made me
write a
wonder.
blog and I write articles for magazines, but I do that more professionally.
Okay.
Personally, I paint and do interior design, and I love to garden.
Oh, really?
Yep.
Whose interior designing are you doing?
Friends.
Can you come to my house?
Absolutely. I'll be there tomorrow. Just give me the credit card and I'm on. No, it's fun. But see, what I do is I turn the phone off at 7 p.m. and it's family time. And so what I do is I create a work-life balance because I have a family, and
work-life balance. That's like
not working in the criminal law, my clients can wait until the morning, and I've taught them how to treat me by responding the next day. And if I'm always available then to all clients, or they know that they can get me within a moment's notice, they'll do that. What they don't realize is that I am always available, and I might respond in a moment's notice if it's justified. But that's a decision that I make. And so in order to have a life and to have free time, I set my boundaries, and I think it works.
good for you. Work-life balance to me is like the tooth fairy, you know.
Invisible and mysterious.
but somehow.
Oh, come on, Dana.
the
You
tooth
must have
goes.
some hobby. What do you do in your free time?
You know, I can at least say what I like to do if I had
That's
free
a
time.
start.
What I
Gotta
used to
start
do.
somewhere.
Dinner and dancing.
Yeah, exactly. I really like socializing with good friends over, you know, some like a fire pit, maybe a cocktail. Just let's relax, talk, make some, you know, memories. I really like just engaging with people.
Yeah.
Yeah, because I don't get to do it as often as I used to.
I have
you
a
know.
fire pit. You can come
Oh, I'm there.
in the garden.
I'm there. I'd say that's what I really like to do in my spare time.
What about you, Ish?
I think
What's
I'm
on
gonna
your
have
weekend
to put
plan?
the two of those together. I like being with people, and I really love the outdoors. So a perfect day for me would be going to the beach or going hiking in the woods or just doing something that really connects me with nature, because I think a lot of our work as attorneys is done either in the courtroom or in an office, and it's just kind of nice to mix it up a little bit.
Do you do anything like run or bike or hike? Do you do anything with regularity?
That will be next year.
New Year's resolution
That's
2015.
right.
I used to run, but then I had an injury, so I had to stop. And I used to, and then I started biking. I used to be part of the Chicago Bike Club, and that was great. That was a lot of fun. And then one time I was part of a book club. That was a lot of fun.
You really wanted to read after doing all the
I thought
reading we
book
have to
club
do
was
for
about
work?
wine. My book club, anyway. Well, I went after a toddler, so wine and socializing and outdoor activities all seem to go hand in hand. But that's what Chicago summers are all
I
about.
think the message is lawyers
thank
are
God
people
Chicago summer is
too,
coming.
right?
Lawyers are people too.
Unlike your pets.
Yeah, my cat is a person. Lucy takes offense to that. She takes offense in her sequins.
Well, thanks for joining us. And feel free to contact us with any suggestions or comments you may have. Just reach out to the show. We'd be happy to hear from you. Have a good night.
Bye.
Hey, you was right on time. I already finished. Okay.
That's great.